It is a unanimous judgment. Now we are going to post it on the CTS soon after its delivery, and therefore we are not going to read the entire judgment. My brother Justice Mugambi will read the analysis and determination of the judgment.
So I will read. We have considered the pleadings of the parties as well as the submissions of the respective counsel, and we now discern the following to be the issues for determination. Number one, whether the jurisdiction of this court to hear and determine this petition is ousted by the doctrine of exhaustion of remedies in the light of Section 40, subsection 2 of the Political Parties Act. Number two, whether based on the provisions of Article 181 and 182 of the Constitution, as read with Section 33 of the County Governments Act 2012, this court can assume jurisdiction over the matter. Number three, whether from a constitutional and statutory standpoint, a governor or a deputy governor who has defected from a political party that they vied on during elections has any legal consequence on their holding office. And number four, whether the first and second respondent defected in effect or can be deemed to have defected from Jubilee Party on the 2nd of June 2023, given the circumstances of this case. Number five, whether the petition is merited. And number six, whether the petitioner is entitled to the reliefs sought. For the reasons that will become clearer in the due course, the first two issues can conveniently be disposed of together. The twofold jurisdictional questions were raised against the jurisdiction of this court by the first and second respondent in their submissions, who contend that based on Section 40 of the Political Parties Act and Article 181 and 182, as read with Section 33 of the County Governments Act 2012, this court lacked jurisdiction to entertain the instant petition. We observe that similar arguments were raised and advanced in a notice of preliminary objection, which, as earlier noted, was disposed of on the 4th of April 2024. In our ruling, we noted as follows, and I quote, open quote, the first ground of preliminary objection is anchored on Section 40 of the Political Parties Act. This section reads as follows. Jurisdiction of the tribunal. The tribunal shall determine A, disputes between members of a political party, B, disputes between a member of a political party and the political party, C, disputes between political parties, D, disputes between an independent candidate and a political party, E, disputes between coalition partners, F, appeals from decisions for registrar and like under this act, and FA, disputes arising of party nominations. Subsection 2 says, notwithstanding subsection 1, the tribunal shall not hear or determine a dispute under paragraphs A, B, C, E, or FA unless a party to the dispute adduces evidence of an attempt to subject the dispute to the internal political party dispute resolution mechanisms. Subsection 3, a coalition agreement shall provide for internal dispute resolution mechanisms. The first and second respondents' argument is that this provision of the law outs the jurisdiction of this court as a dispute before is a dispute between members of a political party and subject to a political party dispute tribunal. A scrutiny of the first and second respondents' pleadings leads us to the conclusion that this may not be a proper ground upon which this petition can be determined in lim. We say so because as much as these respondents are we say so because as much as these respondents are proceedings on assumption that the petitioners are members of the Jubilee Party, they have in their own submissions prevaricated or flip-flopped and denying that the petitioners are such members. In particular, in paragraph 1.17 of the submissions filed on behalf of the first and second respondents, it has been submitted as follows. The petitioners have also not demonstrated to this court that they are members of the Jubilee Party, hence entitled to present this dispute for determination before this court. They cannot purport to bring these proceedings as members of the Jubilee Party before first satisfying the court that they are bona fide members of the party. End of quote. This submission betrays the first and second respondents' stance that the petitioners are members of the same political party as the first and second respondents. It also undermines the argument that the dispute before court ought to have been subjected to political parties dispute tribunal on the basis that the petitioners, on the one hand, and the first and second respondents, on the other hand, are members of the same party. If, we were to take the first and second respondents at their own word, and we have no reason not to, the questions of whether the first and second respondents are members of the same party as the petitioners is a question of evidence which can only be interrogated at the hearing of the petition and not at the preliminary stage of these proceedings. This is because while the first and second respondents deny that the petitioners are members of the Jubilee Party, the petitioners have themselves categorically sworn on oath that they are members of that party. In paragraph 3 of the affidavit of Guyo Ari Guracha, sworn on 13th June 2023 in support of the petition, he has stated as follows, quote, that my co-petitioners and I are members of the Jubilee Party of Kenya and Kenyan citizens. We are filing this constitutional petition in order to defend the Constitution of Kenya as declared by Article 3, Sub-Article 2 of the Constitution, end of quote. We need not belabor the point, save to state that where there is a dispute as to facts, such facts cannot be a basis for a preliminary objection. The case in point on this proposition is the oft-cited Mukisa Biscuit Manufacturing Company versus West End Distributors as 1969 EA at page 700, paragraph DF, Law JA, as it then was, and this to say on what a preliminary objection entails. Quote, a preliminary objection consists of a point of law which has been pleaded or which arises by clear implication out of pleadings and which, if argued as a preliminary point, may dispose of the suit. Examples are an objection to the jurisdiction of the court or a plea of limitation or a submission that the parties are bound by contract giving rise to the suit to refer the dispute to arbitration, end of quote. And at paragraph 701, paragraph B, C, Sir Charles Newbold stated, quote, a preliminary objection is in the nature of what used to be an imura. It raises a pure point of law, which is usually on assumption that all the facts pleaded by the other side are correct. It cannot be raised if any fact has to be ascertained, or what if is sought is the exercise of judicial discretion, end of quote. The first ground of preliminary objection would fail for the reason that the first and second respondents appear to approbate and reprobate on the question of petitioner's membership of the Jubilee Party, and secondly, that the fact may need to be ascertained. The second limb of the objection also featured prominently in the preliminary objection, and our decision was as follows. The second ground of preliminary objection is that this Honorable Court jurisdiction is ousted by the provisions of Articles 181 and 182 of the Constitution and Section 3 of the County Governments Act. Perhaps to understand the first and second respondents' objection on this ground, it is necessary that we reproduce these provisions of law here. Article 181 of the Constitution reads as follows. Maybe I will just leave that so that we can, because it's a direct citation from the Constitution, and also Section 3 of the County Governments Act, which we have reproduced, so that I can go to what we said. Article 181 prescribes instances when a governor may be removed from office, while Article 182 provides circumstances under which the office of the governor may become vacant. Section 33 of the County Governments Act prescribes the procedure to be followed in the quest to remove a governor from office. This section gives effect to Article 181, Sub-Article 2 of the Constitution, which, as noted, tasks the legislature with the duty of enacting legislation providing for the procedure of removal of a county governor or on any of the grounds mentioned in Clause 1 of Article 181. Of the 15 prayers the petitioners have sought, there is none that specifically seeks removal of the governor, at least as contemplated under Article 181, Sub-Article 1 of the Constitution. The only prayer that comes close to touching the office of the governor, but is nowhere near seeking the removal of the governor, is prayer D, which is to the effect that D, an order of permanent injunction be issued to restrain the first and second respondents from discharging any function or duty as a governor and deputy governor of Isiolo County. End of quote. We are of the humble view that an injunction sought in terms of prayer D in the prayers in the petition and prayers for removal of the governor on any of the grounds prescribed in Article 181, Sub-Article 1 of the Constitution are two different things, and one cannot be assumed to mean the other. As far as we understand the petitioners, their case is that by their conduct, the first and second respondents have subverted the Constitution in various respects, including undermining multiparty democracy, which the Constitution espouses. If, At the close of the hearing of the petition, the petitioners have indicated in this regard, or the court finds that the first and second respondents have violated the Constitution in any way, that may be a ground for their removal, in which event Section 33 of the County Government Act will kick in and the process of removal may be commenced. We think the first and second respondents' apprehension that the petitioners are seeking their removal from office in this petition is misplaced. We are also of the humble opinion that the argument that this Honorable Court is deficient of jurisdiction to dispose of this petition on the ground that the petitioner seeks the removal of a governor and his deputy is premature and, at best, misconceived. In any event, even if it was to be assumed that the petitioners have, in one of their 15 prayers, sought for the removal of the governor, that alone will not be fatal to petition. The most the first and second respondents can derive out of what they think are the petitioner's misstep is to persuade the court to decline to grant that particular prayer. The entire petition will not fail at the preliminary stage only because the petitioners are prayed for an order that cannot be granted. We will thus not belabor the point, end of quote. So we will thus not belabor the point on the first two issues raised in this petition, save to reiterate that we adopt the position we took on these issues in our ruling on preliminary objection. The next issue is on whether, from a constitutional and statutory standpoint, a governor or a deputy governor who was defected from a political party that they vied on during elections has any legal consequence on their continued holding of those offices, calls for an in-depth analysis and, of course, determination. In our view, this is the overarching issue upon which the petition turns. The petitioners assailed the first and second respondents' conduct on the 2nd of June 2023, alleging that it was a defection to another political party which undermines the principles governing multiparty democracy, and thus the court should declare the first and second respondents by their action resigned from their positions as governor and deputy governor of Isiolo County. This contention presents two secondary issues, each of which we will discuss at a time. These issues are whether a governor or deputy governor resignation from the sponsoring political party can trigger the loss of the seat of governor or deputy governor, and whether, in reality, there was resignation of the first or the second respondent, or they could, by whatever conduct complained of, be deemed to have resigned from the Jubilee Party as to bear the consequences that legally may ensue such a conduct. Turning to the first link, we start by restating prayers A and B of the petition. They read, and I quote, "A declaration be issued to declare the first and second respondents resigned from their positions as governor and deputy governor of Isiolo County upon defecting from the Jubilee Party to the United Democratic Alliance Party on the 2nd of June 2023. B, a declaration be issued to declare that in defecting from Jubilee Party to United Democratic Alliance, the first and second respondents breached and severed the socio-political contract with the electors of Isiolo and the members of the Jubilee Party to continue serving as governor and deputy governor of Isiolo County." End of quote. The question thus becomes, would defection of a governor or a deputy governor per se constitute resignation from the seat of the governor or deputy governor under the Constitution or legislation? We must commence by restating the core pillar of Kenya's identity as a republic in the affirmation that it is a multi-party democratic state. Article 4, sub-article 2 of the Constitution states, and I quote, "The Republic of Kenya shall be a multi-party democratic state founded on national values and the principles of governance referred to in Article 10. The other key feature that is included in our identity as a republic are the national values and principles of governance. It is important to remind ourselves that this article did not casually find its way into our constitutional architecture. It was a culmination of decades of struggle and sacrifices made by Kenyans for the democratic governance and political freedom from the repressive one-party rule. That historical context is richly captured in the final report of the Committee of Experts on Constitutional Review dated 11th October 2010 as follows, open quote, "The struggle for constitutional reform 1992 to 2010, the advent of multi-party democracy and the beginning of formal process of constitutional reform 1992 to 2002. A wind of change swept across Africa in the early 1990s and popular resistance to dictatorial and perpetuating regime's rule. In Kenya, political pressure for restoration of multi-party democracy intensified, and in 1991, Section 2A was repealed, end of quote. Section 2A, to which reference has been made in this quotation, introduced a dual one-party state. It is thus not difficult to appreciate why Kenyans deliberately chose to protect multi-party democracy as a key component of our collective identity as a republic in August 2010. Needless to say, the quest for multi-party democracy was a major driving force for the constitutional reforms that culminated in Constitution of Kenya 2010. This Honorable Court has a constitutional duty as a guardian of the Constitution under Article 3, 23 and 165 of the Constitution to ensure that these gains do not dissipate through any form of action or inaction on the part of the political class or as a result of the conduct of any person or entity. Kenyans are not prepared to relive the dark and painful one-party state experience. In interpreting the Constitution, Article 259, Sub-Article 1 directs that the Constitution be interpreted in a manner that promotes its purposes, values, and principles, advances the rule of law, and the human rights and fundamental freedoms in the Bill of Rights, permits the development of the law, and contributes to good governance. Bearing this background in mind, the pertinent question that presents itself is whether party hopping, if we may call it that way, outside the legal framework for political parties cooperation, such as coalition or mergers, contribute and promote good governance or promote values, purposes, and principles of the Constitution. Turning to the case at hand, would migration by the governor and his deputy from a party that sponsored their candidature for election to these offices to another after the election, outside the legal parameters, contribute to these constitutional virtues? We think not. Our approach to these questions respectively contrasts with the position on the same question which arose in George Obuya, Owor, and two others were Zachary Okoth Obando and three others, 2017 EKLR. The brief facts in that case were that the governor of Migori County decamped from PDP, a political party in which the governor was a member and on whose ticket he was elected as governor, and joined another party, Orange Democratic Movement. According to the petitioners in that case, the decamping was contrary to the provisions of the Constitution and the Political Parties Act, specifically Sections 14, subsection 4, 5, and 34F thereof, which outlaw concurrent membership of political parties. The court dismissed the petitioner's argument and in so doing, it held as follows, and I quote, open quote, "In our view, and the intention of the drafters of the Constitution being that the office of the governor and the president should fall vacant once the holders of those offices change their political alliance, then Articles 182 and 146 of the Constitution would have made specific provisions to that effect. We say this upon due consideration of the functions of the governor at the county government level and those of the president at the national government level. The powers of these two offices are executive in nature. The governor and the president perform executive functions in the county and national governments respectively. Their duties entail working for every resident in the county or nation as dictated by the Constitution and the relevant legislation, irrespective of their party affiliations. This is to be contrasted with the duties and functions of members of county assemblies and parliament, whose core mandate is representative and legislative in nature, and who have to support and propagate ideologies and agendas of their respective sponsoring political parties in parliament or county assemblies." End of quote. The court concluded inter alia as follows. It is therefore our finding, and we so hold, that the seat of a county governor does not fall vacant upon the holder resigning from a sponsoring political party. End of quote. We respectively depart from this finding because political parties are keen drivers in nurturing democratic ideals and constitutionalism. They are not mere tools for contesting elections and thereafter discarding them. If that practice was to gain track, the political class will benignly claw back all gains made and cripple political parties from their role of ensuring checks and balances necessary for political stability of the country. We are alive to the fact that Constitution under Article 180, Sub-Article 2, provides for election as county governor, one must be eligible for election as a member of county assembly. This would thus take us to Article 193, which provides for the qualifications for election as a member of County Assembly. These include the requirement that one must be a registered voter, he must satisfy any education, moral, and ethical requirements prescribed by the Constitution or an Act of Parliament. He is either nominated by a political party or an independent candidate supported by at least 500 registered voters in the ward concerned, among others. Our focus here is the requirement for nomination by a political party under Article 193, sub-Article 1C. When one chooses to contest for elections on a political party, it has to be appreciated that the election is not just about the person alone. Party affiliation and ideology also play a critical part in the decision made by the voters during such an election. It would therefore be a serious political deception and lack of regard for the electorate for one to go about changing political parties without regard for the electorate. If the culture of irregular party hopping is allowed to thrive, where would that leave the principle of public participation as far as the electorate that participated in the election is concerned? What will become of the principle of accountability and transparency? Such culture, in our view, is a breach of public trust and undermines the national values and the principles of governance and Article 10, which with multipartyism are conjoined twins in defining Kenya's identity as a multi-party democratic state set out in Article 4.2 of the Constitution. The haphazard and irregular defections are bound to weaken and erode political parties, thereby breeding serious repercussions in the democratic environment, as well as much-guarded national values and principles of governance, thereby destroying the fragile substratum of multi-party democratic system of the country. The question is, what would be the reason for what would be the reason for haphazard party hopping when there is a legal mechanism for an open and genuine collaboration between parties to promote multi-party democracy as provided in Section 10 and 11 of Political Parties Act, Cap 7D. For avoidance of doubt, these provisions provide as follows. Section 10 is on coalitions. It says, two or more political parties may form a coalition or a coalition of political parties before or after an election and shall deposit the coalition agreement with the registrar. Subsection 2, a coalition agreement entered into before an election shall be deposited with the registrar at least 3 months before that election, provided that, in the case of coalition party, the coalition party shall submit the coalition agreement at least 120 days before a general election. A coalition, subsection 3, a coalition agreement entered into after an election shall be deposited with the registrar within 21 days of signing of a coalition agreement. And subsection 4, a coalition agreement shall set out the matter specified in the third schedule. Section 11 talks about mergers. It says, a political party may merge with another political party by, and this is long, A, forming a new political party, B, merging into an already registered political party. Subsection 2 says, a political party shall not merge with another political party unless the merger is in accordance with the Constitution, rules, and procedures of the political party. Subsection 3, the decision to merge shall be in writing and shall be duly executed by political party officials authorized to execute agreements on behalf of the political parties. Subsection 4 provides, the governing body of each political party that intends to merge under subsection 2 shall, A, determine the Constitution, rules, regulations, and principles which shall form the basis of merger in accordance with the Constitution of the respective political parties, and B, sign the merger agreement. 5, the merger agreement signed under subsection 4B shall be deposited with the registrar within 21 days of signing of the agreement. 5A, upon receipt of the merger instrument under subsection A, the registrar shall immediately withdraw and cancel the certificates of registration of all political parties that are merged and shall gazette the dissolution of the merged parties within 7 days and certificate of full registration issued to the new political party. 6, upon receipt of the merger instrument under subsection 1B, the registrar shall gazette within 7 days the resolution of the parties that have resolved to dissolve and the registered party the parties have merged into. Then 7, where a party merges under this section, a member of the political party that has merged with another political party shall be deemed to be a member of the new political party. 8, despite subsection 7, a member who is a president, deputy president, governor or deputy president, member of parliament or member of county assembly, and who does not desire to be a member of the new political party registered under the merger shall continue to serve in such elected office for the remainder of the term and may join another political party or choose to be an independent member within 30 days of registration of the new party. Subsection 9, where political parties have merged and dissolved, the particulars including their names, symbol, logo, slogan, and colors shall be removed from the register of political parties, and such names, symbols, logos, slogans, and colors shall not be available for registration by any person as a political party in the subsequent election following the merger. Subsection 10, despite subsection 9, where the merging parties wish to register and use any of the merging parties' names, symbols, logos, slogans, and colors, such registration shall be permitted. And then 11, the records, assets and liabilities, rights and obligations of all the dissolved political parties shall be the records, assets and liabilities, rights and obligations of the new political party, including their entitlement to the political party's fund under section 25 of the Act. So that is it for section 10 and 11. Section 14A, subsection 6 of the Political Parties Act clarifies that a member of a political party cannot be deemed to have resigned from a political party if it can be shown his or a political party has entered or is proposing to enter into a merger or coalition with another political party. Consequently, party hopping without the involvement of the party as provided in section 10 and 11 of the Political Parties Act, Cap 7D, is a selfish practice that raises serious ethical and integrity concerns, which in themselves are contrary to the national values and principles of governance and Article 10, sub-Article 2 of the Constitution. If this culture is entrenched, it will spell a death knell to our nascent multiparty democracy. Following these provisions of law, political party discipline is obligatory, and parties have a responsibility to enforce discipline within their constitutive instruments and, of course, the relevant legislation. Given our constitutional and legal framework, we can emphatically state that there is no room for indiscriminate and unauthorized defection from the sponsoring party by any elected official. The consequences that would visit members of the county assembly or members of parliament who unprocedurally abandon their sponsoring parties after the election would similarly befall governors and their deputies. I now go to the second issue, which is whether the first and second respondent defected in fact or can be deemed to have defected from Jubilee Party on the 2nd of June 2023, given the circumstances of this case. It now becomes necessary to consider whether it was established that the first and second respondent defected from the Jubilee political party on 2nd of June 2023, or if the conditions necessary for deeming them to have defected were fulfilled in the manner provided in the Constitution or legislation. It is the responsibility of whoever alleges an allegation of fact to prove it. This is what Section 107 of the Evidence Act requires. It provides thus, and I quote, burden of proof. Whoever desires any court to give judgment as to any legal right or liability dependent on existence of facts which he asserts must prove that those facts exist. End of quote. The Supreme Court, in Guer and 5 others was Kenya Medical Research Institute, restated the principle as follows. Section 108 of the Evidence Act provides that the burden of proof in a suit or procedure lies on that person who would fail if no evidence at all were given on either side. Section 109 of the Evidence Act declares that the burden of proof as to any particular fact lies on the person who wishes the court to believe in its existence, unless it is provided by any law that the proof of that fact shall lie on that particular person. This court in Raila Odinga and others was Independent Electoral and Boundaries Commission and others. Petition 5 of 2013 restated the basic principle on the shifting of the evidential burden in these terms. Quote, a petition should be under obligation to discharge the initial burden of proof before the respondents are invited to bear the evidential burden, end of quote. To begin with, we will observe that there is no direct evidence, written or otherwise, expressly conveying the resignation of the first or second respondent from the Jubilee Party. There is no letter, a recording, or evidence of the witnesses that gives descriptive details of how the said resignation occurred on 2nd of June 2023. On resignation, the first petitioner attests to the fact of resignation at paragraph 14 of his affidavit as follows, and I quote, paragraph 14, that the foregoing notwithstanding, on 2nd of June 2023, the first and second respondents suddenly changed their political affiliation when they announced their defection from Jubilee Party /Azimio la Umoja Coalition and joined the United Democratic Alliance, UDA, the third respondent hearing, end of quote. The first and second respondents specifically denied the contents of paragraph 14 of the petitioner's supporting affidavit by stating as follows in their replying affidavit. That is paragraph 15 of the first and second respondents' affidavit. It states as follows, that the contents or paragraph 14 of the supporting affidavit of Guyo are denied in total and the petitioners are put to stick proof thereof, end of quote. The denial by the first and second respondent means that the petitioner and the burden to adduce sufficient, credible, and admissible evidence to prove the fact of defection. The first respondent also takes a position that no law obligates him and the second respondent to govern Isiolo country on the first and second interested parties' ideals, agenda, vision, manifesto, and aspiration of the members and supporters. According to the records held by the register of political parties, the fourth respondent, the first and second respondents remain duly registered members of the Jubilee Party. No notices of resignation from the said party have been launched with the fourth respondent, nor has the first interested party submitted any decision indicating that it has terminated its relationship with the two respondents. In the absence of such formal notification, the fourth respondent asserts that the legal threshold for resignation or defection as contemplated under Political Parties Act 2011 has not been met. According to IEBC, no notification has been received from the Register of Political Parties or any competent authority indicating that the first and second respondents have resigned from their sponsoring political party or vacated office. The affidavit of the petitioner is completely silent on crucial facts. It does not indicate where the alleged defection actually took place, the medium through which the first and second respondents communicated or manifested their defection, or how the petitioner came to know about the defection. In our view, the petitioner made a barren claim that has not been substantiated. There is scanty information which in our view does not meet the evidential threshold for making a finding that the first and second respondent defected to UDA on the 2nd of June 2023. Without the evidence, we are unable to satisfy ourselves on the question of whether the conduct complained of constituted what is referred to as deemed resignation from a political party under Article 1 or this of Article 3 of the Constitution, as read with Section 14A of the Political Parties Act. We thus find the petition lacks merit and is hereby dismissed. We make no orders as to costs.
We thank the court for upholding the principle of protecting democracy.